My brother got the car. He got the title, the keys, and everything he said was rightfully his. He stood in that parking lot and smiled like he had just won something. And maybe he had. But 3 days later, his lawyer called mine and asked one question that changed everything. Let me take you back to where this started. 4 years ago, my brother, I'll call him by what he always called himself, the practical one, came to me with a problem. He needed a vehicle. Not a want, he said. A need. He had just started a new job as a site supervisor for a construction company outside of Barrie, Ontario, and the position required him to drive between job sites daily. The problem was his credit. A few years of missed payments, a collections account he swore wasn't his fault, and 2 declined loan applications. The banks wouldn't touch him. I was 28. I had been careful with money my entire adult life. I had a good credit score, a stable job in healthcare administration in Toronto, and a small but steady savings account I had built since my early 20s. I had never missed a payment on anything. Not a credit card, not my student loan, nothing. I was, by every financial measure, reliable. He came to me the way he always came to me, not asking exactly, more like presenting a situation and waiting for me to solve it. He laid out the numbers. The truck he wanted was a used 2019 Ford F-150 from a dealership in Barrie. Just under $22,000. He had $4,000 saved for a down payment. He needed someone to co-sign, or better yet, to put the loan in their name entirely. He promised he would make every payment. He promised it would never touch my credit. He promised a lot of things. I told him I needed to think about it. I called my mother that night. She said he really did need the truck for work. She said he was trying to get his life together. She said family helps family. I called my aunt, who has always been the voice of reason in our family, and she said the same things with slightly different words. I was the older sister. I was the responsible one. I had the means to help. I said yes. We went to the dealership together on a Saturday in late October. I signed the loan documents. $18,000 financed over 5 years through a bank, at a rate that reflected my credit, not his situation. The truck was registered in both our names at Service Ontario, but the loan, the monthly obligation, was entirely mine. The payments were set up to come from my account. He would e-transfer me his share every month. That was the agreement. That was the plan. For the first 8 months, it worked. Not perfectly, but it worked. He would send the money a few days late sometimes. Once it was almost 2 weeks late and I had to cover it myself to avoid a missed payment. But the money always came, and I told myself this was fine. This was just how he operated. This was temporary. Then the pandemic hit, and everything shifted. His company scaled back operations. His hours got cut. And the e-transfers stopped. I understand that 2020 was hard for everyone. I know that. But I was also dealing with a healthcare system in crisis, working longer hours, navigating my own fear and exhaustion, and still covering a loan payment every single month for a vehicle I did not drive and did not need. I texted him. I called him. He said he was working on it. He said he'd catch up. He said things were complicated. 8 months passed without a single payment from him. I kept paying. I did not miss a single installment to the bank because the loan was in my name, and my credit was not something I was willing to sacrifice for anyone. But I started tracking everything. Every payment I made that he did not reimburse. Every late fee when he was slow and I had to scramble. Every dollar. By the end of 2021, he owed me just over $9,000 in missed reimbursements. I have the records. I have every bank statement, every e-transfer request, every unanswered text. I kept everything in a folder on my phone and a backup spreadsheet I updated every month. When I brought it up at Christmas that year, he told me I was being dramatic. He said he had been going through a hard time and I was making it worse by putting a dollar amount on family. My mother looked uncomfortable. My aunt changed the subject. Nobody said anything useful. In early 2022, he got a better job. New company, better pay, more stable hours. He started making payments again, but never the full catch-up amount. 100 here, 200 there. He acted like he was doing me a favor. Then, in the spring of 2022, something broke in the truck. The transmission started slipping. He called me, and for a moment I thought maybe this would be a turning point. Maybe he would handle it, deal with the mechanic, pay the bill, take responsibility for the vehicle he had been driving for 2.5 years. Instead, he asked me to book it in under my name because the warranty paperwork was in my name and it would be easier. I booked it in. The repair was $3,400 at a certified shop in Barrie. The extended warranty he had talked me into purchasing when we bought the truck covered about half. I paid the remaining $1,700 out of pocket. He said he would pay me back. He did not. 8 months later, the brakes needed replacing. Another $900 at a different shop because he had moved. I covered it because the truck was still in my name, still tied to my insurance, and I was not going to let a mechanical failure become a liability issue for me. He sent me $200 2 weeks later and said we were square. By the summer of 2023, the total he owed me missed loan reimbursements, repair costs, insurance contributions he had agreed to and not paid, was just over $14,000. I wrote it all down. I had receipts for every repair. I had the loan statements. I had the insurance records. I had a very clear picture of what 4 years of this arrangement had actually cost me. I also had a growing sense that this was never going to resolve itself naturally. I contacted a lawyer. Not to sue him immediately, I genuinely did not want to do that. I wanted advice. I wanted to understand my options and what the paperwork actually said and what my exposure was if something happened with this truck that I was legally connected to. My lawyer, a woman in her 40s who specializes in civil matters and who I found through a referral from a colleague, went through everything carefully. She told me that because the loan was in my name and the vehicle was registered with my name on the title alongside his, I was jointly liable for anything that happened. If he got into an accident, if he stopped paying and the bank came after the debt, if there were any outstanding issues attached to the vehicle. She was direct about it. I needed to either formalize the repayment agreement in writing, get my name off the title, or be prepared for the consequences of neither. I went home and thought about it for a long time. I called my brother. I told him I needed us to sit down and sort out the finances on the truck. I told him I had the numbers and I needed him to look at them. He agreed, which surprised me. We met at a coffee shop in the east end of the city. He had moved to Toronto by then, and I laid out the spreadsheet. Every line item, every month, every dollar. He looked at it for a while. Then he told me the numbers were wrong. He said he had made more payments than I was showing. He said I was inflating the repair costs. He said the arrangement had always been informal, and I couldn't hold him to numbers we had never put in writing. I stayed calm. I asked him what number he thought was accurate. He said he didn't owe me more than a few thousand, maybe. He said I was trying to take advantage of a difficult few years he'd had. He said a lot of things that made it clear he was not going to engage with this honestly. I told him I thought we should work with a mediator. He said he didn't need a mediator to have a conversation with his sister. I told him the conversation wasn't going anywhere without one. He got up and left. 2 weeks later, I received a letter from a paralegal he had hired. The letter stated that my brother was claiming sole ownership of the vehicle on the grounds that he had been the primary driver and had contributed substantially to the payments over the loan term. It said that my name on the title was a formality related to financing and did not reflect true ownership. It requested that I sign over the title to him within 30 days, or they would pursue the matter further. I read that letter 3 times. My lawyer was less surprised than I was. She said this kind of move, reframing a financial arrangement as an ownership dispute, was not unusual when someone wanted to avoid a debt conversation. She walked me through what we could do. We could fight it, document his contributions versus mine, go through the process of demonstrating who had actually carried the financial weight. That would take time and money, and would likely go in my favor given the paper trail I had. But it would not be quick. Or, she said, carefully, there was another option. She had been looking at the specifics of the vehicle history. The truck had 2 repair invoices associated with it that had not been fully paid off in the normal sense, specifically, the transmission repair from 2022. When I had paid the balance after the partial warranty coverage, the shop had registered a lien against the vehicle through the PPSA, the Personal Property Security Act registry in Ontario. The lien was still technically active because the shop had not formally discharged it after I paid. It was an administrative oversight on their part, but it was real and it was registered. My lawyer explained this quietly. If I were to sign the title over to my brother, which is what he was demanding, the truck would transfer to him along with that registered lien. The lien did not disappear because ownership changed. Whoever held the title held the obligation to clear it, and because I had paid the repair cost, I could, if I chose, request that the shop reassign the lien in my favor, reflecting the outstanding reimbursement my brother owed me for that repair. There was a legal mechanism for this. It was not common, but it was valid. She was not telling me to do anything. She was explaining what existed. I asked her what would happen if I simply agreed to his demand. Signed the title. Let him have it. She said his paralegal and his lawyer, whoever they were working with, should have done a PPSA search before filing that letter. It was standard practice. If they had done it, they would have seen the lien and they would have advised him differently. If they had not done it, or had missed it, that was their error. I told her I wanted to think about it overnight. I want to be honest about what I felt in those 24 hours. I was angry, yes. 4 years of covering payments, absorbing repairs, being made to feel dramatic for wanting to be paid back. I was tired and I was angry. But I was also sad. This was my brother. I had helped him because I believed in him, or at least in the version of him I wanted to believe in. The person who sat across from me in that coffee shop and told me my numbers were wrong was not a stranger. He was someone I had known my whole life. But I also knew that if I fought the title transfer, it would be a long, expensive process. My lawyer's fees would climb. His paralegal fees would climb. It would drag through small claims or divisional court, take months, and at the end of it I would have a judgment that I would then have to collect on which, given his track record, was its own challenge. I called my lawyer the next morning and told her I wanted to proceed with signing over the title. I told her to let his paralegal know we would agree to the transfer. She paused. Then she said, very calmly, "Are you sure?" I said I was sure. She said she would handle the paperwork, and she would also make sure the lien situation was properly documented. The signing happened on a Tuesday. I met with my lawyer, signed the transfer documents, and she filed them. The truck passed to my brother's name entirely. His paralegal sent a brief note saying they were satisfied with the resolution. My brother sent me a text that said, simply, "Thanks." That was it. My lawyer had also, quietly, contacted the repair shop in Barrie and requested that they formally reassign the lien to me as the individual who had paid the outstanding repair cost, on the basis that the registered debtor, my brother, as the primary beneficiary of the repair, had not reimbursed me. The shop was cooperative. It was a straightforward administrative process. It took less than a week. The lien, now properly assigned, remained on record against the vehicle. 3 days after the title transfer, my brother tried to refinance the truck. He had found a lender who would let him take out a small loan against the vehicle's value. He wanted the cash. The lender ran a standard PPSA search as part of their due diligence. The lien came up. His lawyer called my lawyer the same afternoon. The conversation, as my lawyer relayed it to me, was brief and involved a great deal of clarification being requested about the lien's origins and validity. My lawyer explained, patiently, that the lien reflected a legitimate unpaid debt related to a vehicle repair, and that it had been properly reassigned through the PPSA registry and would remain on record until it was discharged, which would require the debt to be PPSA registry settled. The number on the lien was $1,700. The repair cost he had never reimbursed me. His lawyer asked if there was any room for discussion. My lawyer said that the lien holder me was open to discussing full discharge upon receipt of the outstanding amount, and that we could provide documentation of all additional amounts owed if his client wished to pursue a broader settlement. My brother called me that night. He did not yell. He was quiet in the way that people get quiet when they realize they have miscalculated something. He said he didn't know about the lien. I told him I hadn't hidden anything. The PPSA is a public registry. His legal team should have searched it. He asked me what it would take to clear it. I told him the lien was for $1,700 and I would discharge it for that amount. I also told him that the broader debt, the $9,000 plus in missed loan reimbursements and additional repair costs, was documented, and I intended to pursue it through small claims court if we couldn't reach an agreement. He said that felt like a lot. I told him I had receipts for every dollar. We went through a mediation process over the following 6 weeks. A neutral third party, a mediator recommended through the Ontario government's public legal resources, helped us go through the documentation, my spreadsheet, his records, the loan statements from the bank, the e-transfer history, the repair invoices. It was not a fun 6 weeks, but it was honest in a way that our coffee shop conversation never had been. In the end, we reached a settlement. He paid me $11,200, a number we arrived at together, accounting for what he could demonstrate he had actually contributed, and what I could demonstrate I was owed. It was less than the full amount I had tracked, but it was real money, paid in 2 installments, and it was accompanied by a signed agreement acknowledging the settlement and releasing both of us from further claims. The lien was discharged the day his first payment cleared. I want to be clear about something. I did not go into this trying to trap my brother or scheme some elaborate plan. I agreed to his demand because fighting it directly was going to cost me more than it was worth, and because once my lawyer laid out what actually existed, the lien, the registry, the legal mechanism, I understood that the truth of the situation was already documented. I didn't have to manufacture anything. I just had to let the paperwork speak. What I learned, after 4 years of this, is that generosity without documentation is not generosity, it's vulnerability. When you help someone and you keep no records, you hand them the ability to revise the story later. They can tell themselves and everyone else whatever they need to believe. But when you have every bank statement, every receipt, every unanswered text, the story doesn't change. The numbers don't change. My brother and I are not close now. We see each other at family events and we are civil. My mother knows some of what happened. She hasn't asked for details and I haven't offered them. My aunt told me she was proud of how I handled it, which I appreciated more than I expected to. The truck is still in his name. It's paid off now, as far as I know. I genuinely hope it runs well for him. I don't regret helping him when he needed it. I was in a position to help and he genuinely needed the vehicle to keep a job that changed his financial situation. That part was real. What I regret is letting the informal arrangement go on as long as it did without putting anything in writing. That was my mistake, and I owned it. But I kept records, and in the end, that was enough. If you are in a situation like this, if you have helped someone financially, if your name is on something you did not expect to carry alone, if someone is telling you that your memory of events is wrong, document everything. Start now, even if you started late. The PPSA registry in Ontario, and equivalent registries in every other province, are public. They are searchable. They are real. A lien does not lie. And the next time someone asks you to sign something, read the whole document before you do. Both of you. That's the part his lawyer learned too late.